Welcome back to Organized, the business law breakdown. I'm Professor Seth C. Oranburg, and if you've been tuning into this season on corporations, you know corporations are special and distinct from other forms like partnerships because corporations have three important features: limited liability, perpetual existence, and a separation of ownership and control. Let's dive into the first of those superpowers, limited liability. This is their invisibility cloak, if you will. It hides the people inside the company from liability from outside. Earlier, we talked about corporate governance, and corporate governance is fundamentally about how insiders act with each other. And we learned about the internal affairs doctrine. But now we're turning to how the outside world treats corporate insiders. Let's start with the general rule. In general, in everyday corporate practice, shareholders are not personally liable for the debts, contract or tort, liabilities of the corporation. They're not liable for its legal judgments. They're not liable for anything the corporation does, except they can lose the investment they put in. And that's what we mean by the limited liability shield. Their liability is limited to the amount that they've invested. And we can understand the shield better by looking at when it fails. So we'll be talking today about piercing the corporate veil. Piercing the corporate veil means holding shareholders personally liable, which is the converse of the general rule. And this can happen in a number of different contexts. It typically happens when the company is small, and less often when the company is large, because the general idea is that courts will pierce when the corporation is being used like the alter ego, an alternative personality of a person. And that's easier to do when there's one person operating it and not thousands. Plus, the reasons that courts pierce, or at least the reasons they claim that are important for them piercing, are more typically associated with small mom-and-pop shops, like failure to follow formalities. And we'll see that the corporate veil isn't bulletproof. And it's often misunderstood. Sometimes it's really oversimplified to say if you commit fraud, courts will pierce. That's not true, especially not in Delaware. It takes much more than mere fraud and what kind of fraud. So we have to look at a number of different factors and try to understand when this veil breaks down. And once we understand that positively, we might be able to understand normatively why it exists in the first place. So let's dive in. Let's begin by revisiting the foundation of limited liability, because when a business incorporates or forms, whether under Delaware law or another corporate law, it creates a distinct legal entity, a corporate person, if you will. And since that person is separate from its owners, we have a theoretical justification for that entity having its own assets and liabilities. And this separation is deliberate. It encourages investment by ensuring that shareholders, the owners who fund that company, risk only the capital they contribute. Imagine investing $100 in a corporation. Would you do that if the corporation's debts could result in losing your house, or only if your home and your car and your legal treatises collection was secure? However, as with any legal invention, the shield of limited liability can be abused, and so we have doctrines that protect against its exploitation, where a founder or a owner of a corporation treats the corporation like a personal piggy bank or uses it as a vehicle for fraud. The doctrine of limited liability loses its legitimacy, and veil piercing is an equitable remedy that tells wrongdoers that you can't hide when you use the corporate shell as your personal alter ego. And I use that term as a term of art because it's one of three major justifications when limited liability might fail. The alter ego theory is one that courts will raise when deciding to pierce. And the alter ego theory holds that when a shareholder or even a parent corporation exerts total domination over an entity, such that it becomes indistinguishable from its owner, the corporate form collapses. It's really just a projection. Picture a single-member corporation where the owner uses corporate funds to pay personal bills, writes corporate checks to pay his own mortgage, and never holds board meetings. The separation doesn't exist in reality, and so courts will disregard the form. The second justification is undercapitalization or fraud, and a red flag is severe undercapitalization. You don't have to have enough money in the company to meet all of your debts, but if you can't pay your debts, especially debts that arise from legal liability like torts, questions arise about whether you're undercapitalized, especially if you are in a dangerous industry. There's a famous case where a company owned several cab companies, and the cab companies hit someone because driving cabs is somewhat dangerous and caused injuries in excess of the amount of insurance that the company carried. And the injured party wanted to pierce. The court said, no, we're actually not going to pierce in this case because the company had the legal minimum amount of insurance. It was meeting its legal requirements. But if it had less, if it was truly undercapitalized, if it didn't have that insurance, it seems like piercing would have been more likely. So undercapitalization is a major reason courts will see the entity as disregardable. And third are policy justifications. The corporate form is designed to foster risk-taking. It's designed to foster economic growth. But while it promotes innovation by offering internal rewards, it does externalize some of the risks. And so to strike this balance with society, it has to ensure accountability. So courts tread carefully to preserve the principle of limited liability. If they pierce too readily, the very purpose of incorporation, encouraging investment, might be undermined. So the law must balance economic incentives with some degree of fairness. A person cannot simply treat a corporation as an extension of their own personal wallet. And that brings us to the nuts and bolts of how courts decide when to pierce and what are the limits of limited liability. We'll have a season on this later, so this is meant to be a preview, but it's just fundamental to the corporate form, the fact of this limited liability. So we have to get some concepts established up front, and then we'll go deeper into them later in our study of corporations and business associations. In any event, in the United States, there's no single uniform test governing veil piercing. Courts rely on a multi-factor inquiry, varies from state to state, and it can be more or less severe. Some jurisdictions express language like alter ego or instrumentality as a doctrine. Others stress terms like unity of interest and ownership. Delaware in particular, known for its protection of corporate formalities, has a very limited carve-out for veil piercing. So let's start there. In truth, there's not a lot of consistency to this doctrine. I'll admit that right up front. But we'll start with Delaware. In Delaware, courts typically require two key elements before they will pierce the veil. Control or dominion is the first one, and using that dominion to commit fraud or injustice is the second one. So I've heard people say that courts pierce when there's fraud. That's a way oversimplification. Fraud is a typical element required for there to be veil piercing, but it is not sufficient. You also need control or dominion, which can be evidenced through other things. Control or dominion means that the owner treats the corporation like nothing more than a tool or a mere instrumentality. So we can look at specific practices, right? Commingling funds, putting private funds and corporate funds in the same account, ignoring corporate formalities such as a board meeting, failing to have separate books and records, paying for personal expenses with corporate funds. Those are all evidence of control or dominion. And control or dominion as a whole is the factor that we need to see, because we will pierce when the owner's control is so absolute that the corporation lacks a separate will of its own, when the corporate boundary is compromised. In addition, second element, it's not sufficient for a shareholder to have just control. We also have to show the second element that that control was used to commit a specific fraud or perpetrate a particular injustice against creditors or third parties. The abuse has to be deliberate, more than just poor record keeping, bad oversight. Delaware courts will look for evidence that the corporate form was intentionally misused to shield wrongful conduct. And again, it looks for both those elements because it takes a relatively narrow approach. Beyond Delaware, many states apply a variant of the instrumentality or unity test, and I'll summarize that with three parts. So the Model Business Corporations Act veil piercing generally has a three-part test. Part one, the owner must exercise complete control over corporate policy and finance, such that the corporation lacks an independent existence. Two, that control must be used to commit a wrong or violate a legal duty. And three, there must be proximate, causal connection between the wrongful use of the corporate form and the harm suffered by the plaintiff. So in essence, if the corporate form is nothing more than a facade, and that facade is employed to inflict harm, then the court may decide the veil should be pierced. So it's not so easy. Courts weigh several factors when determining whether to disregard corporate separation. And so to run through those factors that are common: failure to hold board meetings, failure to maintain minutes, commingling of personal and corporate assets or funds, inadequate capitalization, especially in relationship to risks inherent in the business, sharing of office space, sharing of phone numbers, sharing of employees between entities, creating blurred boundaries, the absence of corporate bylaws, or the absence of a functioning structure, or the disregard of those structures, and other evidence that the corporation shields fraudulent or wrongful conduct. Again, it's a complicated doctrine. You can't just boil it down to fraud equals piercing. Not only is that an oversimplification, but remember that fraud has to be directly associated with the harm that results from it, as well as needing to see some of these other factors. And again, the reason is we do want to protect the corporate form by and large because it's a vehicle for investment, and it also creates unfairness if we pierce too easily. Let's take a look at some illustrative scenarios that might bring these abstract principles to life. One common scenario where we see veil piercing is closely held business or family-owned corporations. Small business often incorporate to enjoy the benefits of limited liability, but especially in a small business or a family-owned corporation, they may fail to rigorously follow formalities. For example, a family-owned swim club that operates with a single owner might routinely pay personal expenses from the club's bank account. This happened in Minton versus Cavaney in California in 1961. And after paying personal expenses from the club's bank account, the court held that the owner, an attorney, was personally liable after a tragic drowning happened at the swim club. Now, it wasn't just this commingling of assets. It's hard to say exactly what factor put it over the top, but in this case, there was also undercapitalization and loose operations. So California said this functioned merely as an owner's alter ego, which is really a legal conclusion more than a set of facts. This case reminds us that even in small operations, failure to observe formalities can lead to devastating consequences. Second common area is parent-subsidiary arrangements. So large corporations often use subsidiaries to isolate risks or to specialize certain ventures. So a manufacturing plant or a real estate holding might be a subsidiary held by a more general conglomerate. If a parent company micromanages that subsidiary, however, and ignores necessary boundaries or leaves it financially hollow, undercapitalizes it, courts may pierce into the corporate group. In such cases, the assets of the parent can be reachable by the subsidiary's creditors. If the parent effectively treats the subsidiary like an alter ego, like a projection of itself, not like a separate entity, it may be forced to answer for the subsidiary's liabilities. A third instance is when there's a shell company and we have a fraudulent transfer. There are situations where individuals form multiple shell entities with minimal capitalizations whose sole purpose is to keep creditors perpetually at bay. And this tactic is often used in fraudulent schemes. So this may be one example where fraud is paramount when you create the corporation for the fraudulent purpose of defrauding creditors by making it difficult to trace and obtain assets. Once the scheme is uncovered, courts may hold the person behind the shells personally liable, regardless of how many corporate names are invented or how frequently the registry is updated. They'll even go beyond following formalities in these extreme cases where the entire purpose of the corporation is formed to perpetuate a fraud. And fourth, the failure to secure adequate insurance. While lack of insurance on its own is not sufficient to trigger veil piercing, it can be a contributing factor because it's similar to undercapitalization. It unfairly externalizes the risk of not having funds to pay for creditors, and so the courts may decide to pierce. And this is particularly true in high-risk areas like hazardous waste disposal or driving cab companies. If a business, through its owner's negligence, maintains minimal insurance coverage and engages in risky operations, and an accident causes injury, the inadequate insurance may signal the business was undercapitalized from the start. In combination with other factors, this can justify piercing the corporate veil. When a court pierces the corporate veil, the consequences for shareholders are severe. Suddenly, their protective barrier dissolves, and their personal assets, their bank accounts, their houses, even their vehicles, can be seized to satisfy corporate debts or judgments. This abrupt shift from limited liability to unlimited liability can be devastating. Creditors can reach personal wealth, Individual shareholders might be forced into personal bankruptcy. And of course, there could be irreparable credit damage. Given these, preventative steps are recommended to safeguard the corporate form, right? First and foremost is maintain corporate formalities. If you choose the corporate form, you're going to need to have regular board and shareholder meetings. You'll have to adopt and follow your bylaws. You'll have to record all major decisions in meeting minutes. And that's true even if it's just you running this thing, which means that another form might be preferable if you don't want to do this stuff, like an LLC. Even small corporations require a paper trail. If your financial records and your corporate governance records are as thin as a legal brief with no citations, you're asking for trouble. Always keep personal and business bank accounts separate. Don't commingle personal bills with corporate funds, period, end of story. In order to run a corporation, you need a corporate bank account. If the finances are too commingled, a court might decide the veil is thin and not maintain limited liability. And in that bank account, there has to be sufficient funds, so maintain adequate corporate funds to pay the likely risks. To a certain extent, insurance can cover for some of this. So if you have minimum insurance coverage, you may be protected. You don't have to have millions of dollars of cash on hand necessarily, but you do need to have enough capitalization for the legitimate business needs. Otherwise, the corporation may be pierced. You have to use proper contracts and signatures. When signing a contract, you do so in your official capacity as an officer of the corporation. So you should write president next to your signature line as opposed to just your name. Clearly state the corporation is the obligor on checks. The stationery should have corporate letterhead. You should have a corporate email address as opposed to sending this from your personal email. These measures further demonstrate that the corporate entity is separate from personal affairs. And in a corporate group, like a parent subsidiary setup, maintain separate books, maintain separate management structure, and maintain separate operational protocols. The clearer the distinction and the more the formalities, the less likely a court will find the entities are so intertwined they may become one. Hey, look, this is all annoying, right? This is all extra stuff to do, but it's the cost of limited liability. It's what you have to pay in order to get that reward. And in our next season, we'll talk about limited liability companies, which don't require so many formalities. Before we go, let's talk about one final situation where we have minority shareholders, because the situations where piercing is most likely is where we have a few shareholders who actually do exert control. But a minority shareholder, by definition, lacks the control required to treat the corporation as a personal alter ego. Simply holding stock in a corporation does not expose one to personal liability. The whole point of limited liability is it doesn't. However, if a silent partner, even a minority partner, not only invests, but tacitly allows or even participates in the commingling of funds or fraudulent activities, they may find themselves dragged into litigation. Generally, when a corporation's wrongful actions harm outsiders, the suit is brought against the corporation. But if a plaintiff alleges the corporate form was abused to the point it became an alter ego, they might name the controlling shareholder or even the obsequious minority shareholders as additional defendants in the case. Even if they lack control, minority investors should be vigilant because they have the responsibility and sometimes the right to raise concerns if they witness sloppy governance or personal use of corporate funds that jeopardize the corporate form. Transparency and adherence to formalities benefit all shareholders, regardless of the size. It's also worth noting that similar practices apply to other business structures. While limited liability companies have fewer formalities, there are piercing the limited liability company veil cases. Calling something an LLC does not automatically shield the owners if formalities are totally disregarded or if they engage in misconduct. At the end of the day, veil piercing looms when the corporate form is abused, when a corporation becomes nothing more than a convenient label for a personal gain or a construction that is designed for the purpose of and does, in fact, create a fraud. By respecting corporate boundaries, establishing adequate capitalization, and maintaining diligent governance, business owners can preserve a protective shield, which is the very reason for incorporating. And with that, that wraps up our introductory discussion on piercing the corporate veil and shareholder liability. We learned how the bedrock principle of limited liability, which encourages investment by limiting investors' risk, disintegrates when the corporate form is misused. And this can happen when it's a small business. It can also happen in slightly larger businesses, but there's an inverse relationship between the size of the business and the likelihood of piercing. The tests differ by jurisdiction, and they're not particularly clear. So we have to look for factors and recognize that there's no one simple answer to whether a court will pierce. Instead, try to avoid some of the practices that lead to piercing because they're both bad governance and leading to risk. I'm Seth C. Oranburg, and I thank you for joining me on this conversation about limited liability and its limitations. We're going to next talk about the next superpower, which is the perpetual existence of a corporate life and the early end to it. So I'll see you in the next episode.